開始今日會議啦，我哋夠鐘亦都夠法定人數。
We have a quorum and it's the appointed time. Welcome to the Bills Committee second meeting. There are two parts to this meeting. The first being a public hearing to receive deputations and individuals. There are altogether 3 individuals and deputations upon the invitation of the Secretariat who have come to speak to us. Afterwards, we will go to the second part, which is a continuation of the last meeting. We have already started clause by clause. I would like to report to you that yesterday a letter CC to this subcommittee and sent to the Department of Justice number CB bracket 4192/18-19 bracket 01. It's been given to members for reference. The first item on the agenda is public hearing. Let's invite the administration, deputations, and individuals to come in. We have with us from the Department of Justice, Miss Diana Lam, Assistant Solicitor General, Policy Affairs, Mr. Wesley Wong, Solicitor General, Mr. Richard Ma, Senior Government Counsel, Miss Selina Chow, Senior Government Counsel, Miss Cindy Church, Senior Government Counsel, and Mr. Ivan Leung, Public Prosecutor. Welcome. Please enter. Welcome. I would like to remind you that if necessary, you may use the earpiece and choose the language channel on the panel. Please come forward. 1 is Cantonese, 2 is English, and 3 is 普通话. Please also pay attention to the notice to members of the public attending electrical meetings in a public hearing or in the public gallery. Those in the public gallery may also ask for a copy from a member of staff. I'd like to remind you all that what you say is not protected by the Electrical Powers and Privilege Ordinance. Because of limitation of time, please pay attention that you will each have 4 minutes. Please be succinct and focus on main points. When you hear the bell, please stop. Refrain from using mixed code language. It may be inconvenient to interpreters. First, from Hong Kong Society for Communication, Community Organization, Mr. Richard Choi. Our society is a concerned group for human rights, where there has been a number of discussions about about hearsay evidence. The LRC report was published about 10 years ago. We should lose no time to make amendments. From the point of protection of human rights, on one hand, we want to protect legitimate rights of defendants in criminal procedures. Existing rules, especially those relating to evidence, should not be changed without good grounds. On the other hand, we have rights of victims in criminal proceedings because of the restrictions of evidence rules, they cannot see that justice is upheld. Both sides are very important. I ask the bill to reflect these two very important areas. SOCO supports the direction of the bill. There has been discussions over many years about hearsay rules. There is classification in the system of the common law, which has been in practice for over 100 years. On a number of occasions, I do see that some views have been taken on board. To a certain extent, the bill covers the circumstances when the court may accept hearsay evidence. Apart from those covered by the bill, say under an agreement, if the witness cannot testify is one circumstance. We do think that you will have to err on the cautious side. We don't have very strong views as to whether the current proposal is the best. But I ask the Department of Justice to take into account views expressed, say for example the submissions from the Law Society. They need to have more discussions with the sector on details. We hope that the bill can be passed and implemented as soon as possible so that our system moves ahead with the times, so that the system can strike a balance between protecting the rights of defendants and witnesses for one reason or another cannot testify in court. Second one is Mr. Yip Jun-yuan, Speaker from the DAB.
To ensure only reliable evidence will be adduced is the cornerstone of our legal system. No doubt that the existing law on hearsay evidence is complex and difficult to understand even for practitioners. We share the views of the Law Reform Commission that it is appropriate for the government to amend the evidence ordinance to clarify the uncertainties of the existing rule and the common law exceptions, and that we support the aims of the bill. In respect of the recommendation proposed by the Law Reform Commission, we shall not further address whether the needs of this amendment is merely academic or there is a real risk of bringing in justice. The Law Reform Commission report in 2009 has focused on the constitutional rights of the defendant in criminal proceedings. We agree that there must have built-in safeguards to protect the rights of the defendants and ensure the integrity of the trial process. However, we note that there will be statutory tests introduced to provide a more flexible rule to allow hearsay evidence to be admissible. We share the views of the Law Society comments submitted to this panel that there is a speculations on the application of the proposed conditions of necessity and the threshold reliability. We do have concern over the application of these two conditions. Among other cardinal principles listed by the Law Reform Commission, we would like to draw the committee's attention on the issue that question of admissibility should be determinable with a fair degree of certainty prior to trial, so that the legal advisor, the petitioners, may probably advise the client on the likely trial outcome, and the bill with the proposals of these two conditions may not be able to allow the petitioners to do the same. We always have concerns on the protection of the victims of sexual offences, including taking part in criminal proceedings. We understand that several sections of the Criminal Procedures Ordinance has provided certain protection to children and the MIP. We do request the committee to consider the protection for these vulnerable witnesses in the proposed bill. Lastly, it's not a surprise that electronic recording, communications, or other forms of instant messaging application would be invoked more frequently in various organized crime. It would be wise for the bill committee to consider this issue in the proposal as well. Thank you, Mr. Speaker.
好，唔該晒。下一位呢係自由黨。
Next is Mr. Wang Qing, the Vice Chairman of the Liberal Party. Thank you, Chairman, for giving the Liberal Party this opportunity to share our views with you. I've been a criminal lawyer for 4 decades, so I have special feeling towards this piece of legislation. Now, for this bill, it affects criminal proceedings most. For civil proceedings, I have no views. I can support that. As for criminal proceedings, a very simple issue is involved. If this passed, then you cannot cross-examine. Now, let us look at paragraph 4, necessity. Now, for a witness, if he's overseas and if he's not willing to come back for cross-examination, and if the prosecution insists on the case, or even if I'm in Hong Kong, I don't want to go to the court because I'm afraid that I will self-incriminate. This is very important. Now, if I point my fingers towards him and I say that he's done that, but I don't want to go to the court because that may incriminate. Now, for this condition of necessity, if the government, if the judge thinks that's admissible, then what kind of trial do you call that? So cross-examination is the most important thing in criminal proceedings. So a person is accusing you, the person should face you. This is the core of criminal proceedings. He has to face you, and the judge is there to take care of justice, and there should be jurors. So the judge cannot decide everything. There is a jury. Otherwise, it will become a paper trial. So we really have to be very careful. I am also a member of the LLC, and I've been sitting on the relevance committee. I object to this because I don't think that's enough safeguard. Why do we need this? Well, for certain offenses, there are mentally handicapped people and they cannot testify in court. He may point his finger at a certain person and he said that another person has done something to him. So this you can use the statutory exemption. That is, he's allowed not to testify in court. Now, if you are doing this major change, then well, actually, all the common law jurisdictions have been looking at this, and now we are adopting the New Zealand model, not the English model. But for the New Zealand model, it's pegged to another law that's called Hayes. That is to monitor police interrogation and investigation. This is very important now because for Hong Kong police, they do not have these guidelines. This is the UK Police and Criminal Evidence Act. Well, this applies to all the Commonwealth countries, but we don't have it. I am a member of that committee already. In 1992, they already had 66 recommendations. But of course, the Security Bureau won't support that, and the police won't support that either. Now you don't have pace, so what can be done? This is now done administratively. Well, we shouldn't legislate on it. If you look at police standing order, well, no, we can't look at it. So there are a lot of problems. So I've said that pace has to be done at the same time because pace affords certain protection. So administratively, of course, security would want to get rid of hearsay. Well, I am a CPCC member, and 90% of the cases rely on confessions, and there's no investigation. The only evidence is confession. So this is what I want to say, Chairman. I hope that the government would consider this. Even if this bill is passed, the commencement date should be deferred until Hong Kong has pace. Thank you, Chairman. Thank you. Well, the deputations have spoken, so I would like to ask the government representatives if they want to respond to the deputations' views. Solicitor General, I would like to thank the Chairman for giving me this opportunity to speak on behalf of the government. And I would like to respond to the deputations. First of all, well, for the Law Society, we would like to thank it well, when the Bills Committee is scrutinizing the bill, they have provided their views to us. Later on, we will give the Law Society a written reply. Of course, this committee would continue to scrutinize the bill, and in the course of doing it, we will touch on the topics that members are concerned about. And at the last meeting, I remember Mr. Kwok talked about the Law Society's views, and there have been some reputations. Now we have started a clause-by-clause examination, and in the course of doing that, I think we can explore a lot of issues. Just now, the deputations have spoken, and there is something very important. That is, we have to strike a balance among all parties during a trial. This is not a one-way road. Now we have to safeguard the admissible evidences, and this is not only to facilitate the prosecution. Well, for this new reform, we may be able to help the accused as well. That is, when they adduce evidence, the evidence can also be admitted. It's not just to challenge the prosecution's evidence. Maybe that would challenge other co-accused. So for the evidence that should be admitted by the court, we do not want to be obstructed by the old rigid rules. And last time we also talked about this, and later on when we looked at the different clauses, this will be mentioned again. That is, there are other safeguard measures. Now there is one very important safeguard measure, that is, if hearsay evidence is involved, and if that hearsay evidence would lead to an unsafe conviction, then the judge would have a responsibility. That is, he should direct the jury to acquit the accused. And I would like to make another point. Just now, the DAB spokesperson mentioned a point. Mr. Yip talked about electronic communications. Well, for the DOJ, I think our draftsman can help to explain later. Well, while we are drafting, we hope that we can be technology neutral. We hope that the advancement of technology would not affect the application of law. Just now, Mr. Choi talked about the fairness between the accused and the prosecution. I've talked about that already, so I'm not going to repeat myself. And for the Vice Chairman of the Liberal Party, Mr. Wu, he mentioned 2 points, and I would like to respond to those 2 points. First is about the UK Police and Criminal Evidence Act 1984. As Mr. Wu pointed out, in 1992, the LRC had a report, and in that report, most of the recommendations have been implemented. Some of them are implemented through administration, others through legislation. No matter what, the relevant implementation have been explained to the security panel. We are grateful that the Liberal Party has been communicating with the DOJ concerning this bill, and we have provided the relevant information to the Liberal Party. Just now, you mentioned the police, and after they arrest a suspicious person, what should be done and how caution should be made. So this is not just about the police internal guideline. There are some gazetted rules which are open to the public, and the Gazette was done in 1992. In the court, through a voir dire proceeding, that is, if the accused has admitted to something outside the court, well, that guideline is still applicable. So for this bill, it's not about the accused own confession. We are talking about other people and the hearsay evidence outside the court. So we don't think there is a need to do this. That is, if the bill is passed, we don't need to postpone the commencement date. As for the second point I mentioned just now, if a witness is unwilling to testify, but this is not the standard used in this bill. Under Clause 55(0), that is the condition of necessity. If you look at 1C, that is whether it's reasonably practicable. So it's not only about the witness' personal intention, whether he's willing to testify in court or not. Now, if we talk about a witness, and if he's worried that he would self-incriminate. Now, if you want to ask this question, we have taken care of it separately. Clause 55(0)(1) (1)(e) takes care of that. It states that the court needs to treat such circumstances specially. Later on, when the Bills Committee continues with the clause-by-clause examination, we can discuss this in greater details. Thank you, Chairman. Members, do you have questions? Please raise your hands. We have 3 members who have raised their hands. First, Mr. Kenneth Leung, second, James Toll, third, Fernando Cheung. 5 minutes for each member. First, Mr. Leung. Thank you, Chairman. I would like to focus on what Mr. Wu said just now. That is about the condition of necessity, clause 55O. Just now, Mr. Wesley Wong talked about 5501C, that is, if the declarant is outside Hong Kong, then that is not a necessity. We have to consider whether it's reasonably practicable. And we have Roman letter 1 and 2 under 1C. So for Roman letter 2, making the declarants available for examination and cross-examination in another competence manner in the proceedings. Does it include the person being overseas? Now, if you want to get an evidence from that person, can that be done? Well, declarant is overseas. So is it possible to do an examination and cross-examination of overseas, or can you do it by video link? Solicitor General, thank you for your question. Well, for this issue, we mentioned it at the last meeting.
If a witness is overseas, there are two ways to deal with it. The first one is letter of request, which means that under Criminal Procedures Ordinance, we can go to the court where the witness, in which the country the witness is in, and then the testimony of the witness can be transcribed and taken to Hong Kong. We can refer to the transcript to see that under what the witness said under cross-examination. This is similar to moving the court setting into Hong Kong. The other way is to make use of a recently amended legislation, I think within the past 3 years. Video link might be used in civil proceedings. With the amendment, criminal proceedings can also use video link as well. So under 55O(c) Roman 2, it is set out for the court to decide whether it meets the condition of necessity, whether it's applicable. If neither one nor two can be done, and there is another declarant which is in Hong Kong, and that declarant is willing to give hearsay evidence in court, I don't really understand. Can this hearsay declarant give hearsay evidence in court? Are there provisions stopping the defense counsel to cross-examine this hearsay witness? Mr. Wong, my understanding of Mr. Wu's basis of objection is that if there is a chance to cross-examine the accuracy of the hearsay evidence, the defense lawyer doesn't have a chance to cross-examine the first-hand witness. I think that is the reason why Mr. Wu objects to it. Under this circumstance, either party, if they want to introduce hearsay evidence, and in order to ensure fairness of the trial, one of the conditions is to be considered will be the condition of necessity, which is 55O. Next, Mr. James Toll. I thank deputations and individuals for coming to give us their comments. I know that Mr. Wu is very experienced criminal lawyer. I would like to hear more from him. I kind of understand him. Under the existing rule, what can happen in the worst case scenario? Perhaps you can elaborate to help us understand so that we can mull over it. I think Mr. Wong is also involved. Well, the key witness said that I'm not coming back to Hong Kong because I'm not fit to travel. Well, it doesn't matter. If you don't come to us, we will go to you. And then we will use their own legal system. Say, for example, I've been to San Francisco. I will issue a witness summons. And then there will be a U.S. judge and a Hong Kong judge. We are responsible for only cross-examination, and there will be a transcription. But under this bill, well, I am in intensive care. That will be the reason. That's why I can't testify, because they know full well that you can't force them to give evidence. So they don't want to give evidence. But the witness has given a statement before, so the prosecution will have it read out, and there is no chance for cross-examination. Why do you want to open this door? The person may say, I don't want to self-incriminate. And if that is the case, why would the judge admit that? If the witness said, well, I don't want to come to testify because I don't want to incriminate myself, and
咩？如果唔得嘅 ，Wesley，then why 立法？
can that be done? And it shouldn't be legislated. Cross-examination is very important. It's not just a common law. Well, if someone accuses you of doing something illegal, then they have to be cross-examined. I've been in practice for over 40 years. There has never been an occasion when I say, well, police said that, well, I am a good person. That is useless. It's only when you say that you have admitted it, or someone said that you have admitted the guilt, that's got probative value. I think I understand the crux of the problem. Can we hear from the administration? We'll say this is my question. Can you give us a written reply? How do you strike a balance between fairness and something else? Would you like to hear from them? Yes, a brief reply will do. Give us your best argument. Thank you. I thank Mr. Hu for explaining once again his stance. I also thank Mr. To for treating that as his question to give the DOJ a chance to explain. The first question, as an example, evidence was taken in a court overseas. This is not mutually exclusive with other alternatives, say for example those ones mentioned by Mr. Kenneth Leung. If the prosecution or the defense would like to go overseas or use a video link to take evidence, it can be done. But if it can't be done, then we will look at the reason. The trial judge will decide and try to strike a balance. The criteria for making the decision is under 5501C. That is the way to handle it. And in relation to 5501A, that is, if someone is concerned that the evidence given may be inculpatory. In the LRC report, this point has been explored. We have taken reference from the Scottish scenario. I understand what Mr. Hu said. The person is concerned that he might self-incriminate himself as a result refuse to give evidence should the court accept his hearsay evidence. There are many possibilities of what might happen. What I say, of course, will not override what court will rule in the future. What comes to my mind is that the witness may be concerned that he may be criminally liable for another offense, not related to this offense under the trial, but some other offenses. As a result, the party cannot summon this witness. Then that party will have to convince the court that in relation to a certain part of the evidence there is this concern, but this concern doesn't exist in other parts of the evidence. Perhaps the court may be convinced to allow the hearsay evidence to be admitted without cross-examination. There is also another scenario. Perhaps the witness who is unwilling to testify cannot be reached. Maybe the reason why he can't be reached is because he doesn't want to incriminate himself, and this provision may be invoked. We'll be happy to provide a written reply as requested by Mr. To. Well, I allow more time because two members have expressed the same concern. The third member, the Dr. Fernando Zhang. Well, after the Cambridge home incident, our attention has been drawn to hearsay evidence. We asked the DOJ to adopt the LRC recommendation as soon as possible. The recommendation relates to vulnerable witnesses or a mentally incapacitated person. When they are in a situation like the Cambridge Home for People with Disability, the person in charge was suspected to sexually abuse a female inmate. The female inmate, through a video recorded interview, stated what happened. However, I remember that on 6 occasions, some professionals, I think they are psychiatrists, were of the view that the victim was not fit to testify in court because it will greatly harm the victim psychologically. As a result, the VIR could not be admitted. Charges were dropped. we think that it is very unfair to the victim. Because under the existing hearsay rule, the evidence she gave, the statement she gave, could not be admitted by the court, so we welcome this change. I have heard Mr. Hu's concern. Let's assume that if the witness said that because I don't want to incriminate myself, I ask for an exemption so that I don't have to be cross-examined. Will it be allowed? I see that there is a condition of necessity. But there are also other conditions to be met. Well, if a defendant is to be cross-examined, of course, the defendant would rather not. I asked the DOJ to explain to me if the amendment to the evidence ordinance will allow people who don't want to be cross-examined to dodge it by invoking 5501E. Then it will be very dangerous. So I would like to hear from the DOJ.
Solicitor General, thank you. First of all, we have to understand this. Previously, I also mentioned it roughly. For this law reform is applicable to both the prosecution and the accused. And for the accused, he doesn't only challenge the prosecution, he can also challenge the words of other co-accused. So if some people are afraid that they would self-incriminate and they refuse to be cross-examined, well, we are not talking about the accused. We are talking about other witnesses. And Mr. Hu mainly talks about the witness of the defendants, but this is, well, the witness of the prosecution, but this is also applicable to the accused witnesses. So you will find this very useful. Now, for the defendant, if he hopes that the defendant's witnesses can appear in court, well, he may encounter difficulties. That is, if this witness is afraid that in the course of cross-examination he would self-incriminate, then it's very difficult for the defendant to ensure. Well, Chairman, can I continue? Please be brief. Then it's very difficult for the accused to make sure that the witness would appear in court. But if we have this bill amended, then for the accused, there is a privilege. If he can convince the courts that under such circumstances, the witness statement taken outside the court can be admissible as part of the case of the defendant, then this would be conducive to the defendant. If you want me to cite scenarios, I can cite this. For example, if a case involves the provision of sexual service, I hope the chairman won't blame me for being rude. Now, for certain cases, they may involve a sexual service provider or a pimp. So the statements are provided to the investigators may benefit both parties. But for the other people involved in the case, well, some of them may not be Hong Kong's permanent residents. They may be repatriated to their countries of origin. So other than this reason, and there may be other reasons under which we cannot assure that they would appear in court. However, if the evidence is very important for the fairness of the court, then if the court thinks that the condition of necessity is met, then such evidence would be admissible. So we don't just think that's enough. There is another safeguard. If the court eventually thinks, that is, before conviction, such hearsay evidence would have to be relied on, and after considering that if it thinks that it's unsafe to convict the accused, then the court has the responsibility to direct the acquittal of the accused. So this is the built-in safeguard. Mr. Paul Chair. Thank you. Well, I don't have as much experience as Mr. Wesley Wong, but I have some experience. Just now, Mr. Wong stresses that for this amendment bill, it's not only to help the prosecution, it can also help the defendant. So, in particular, when other co-accused evidences are relied on, I would like to ask the government, well, for our common law system, it seems that we are inclined towards the defendant. Now, when we study law, we understand that we do not want to convict people if there is doubt. So now, are we redrawing the line so that we would facilitate the prosecution more? Of course, we all know that the defendant can just sit there and do nothing. And if your effort is not good enough, then under the present system, the defendant would be treated favorably. So does the administration think that our system has to move forward a bit, and the benefits given to the accused should be taken back to a certain extent, and the prosecution's power should be bigger so that justice can be done more easily? Just now, Mr. Fernando Zhang cited some examples. So, for example, the Cambridge home or the bridge of rehabilitations example. Now, for our legal system, well, after 1997, there have been some changes to our system, and there may be some cultural changes, and it seems that the safeguard has decreased. So I would like to ask the Solicitor General, why do we need such a change? I would like to thank Mr. Chair for his questions. It gives me the opportunity to explain to you more about our policy. Well, we are not favoring the defendants, but we are using the common law system. This is a deep-rooted policy in our system. That is, we do not want to convict people if there is doubt. And we are not redrawing the line. The major purpose is this. Well, this is clearly delineated in the LLC report. Now, for hearsay evidence, under the common law principle, well, we find that there are a lot of places that are illogical, and there are places that are not clear, and there are even contradictions in certain areas. So for all the common law jurisdictions, many of them have conducted studies concerning this, and their conclusion is that a reform is needed. In the course of carrying out the reform, we have looked at many common law jurisdictions' experiences, and eventually we have adopted the New Zealand model. No matter what, our main purpose is to rationalize some illogical areas under common law. Because of this, we have to do this through statutory law, and this is what we see under 55P and 55O. These are the condition of threshold reliability and the condition of necessity. These are very strict conditions. Only under such strict conditions can hearsay evidence be admissible. If you are saying that this would give less protection to the accused, this is not the purpose of the bill. If you look at 55Q, you will see that this is an overriding provision. That is, the court must direct acquittal if it is unsafe to convict. So for this clause, for unsafe, it is exactly what the appeal court would look at. The present provision is unsafe and unsatisfactory. Well, the standards are the same. So the goal is that we do not hope innocent people to be convicted. We try to make trials fairer, and for admissible evidences, we want them to be admitted. So that is why we are rolling out this reform. Mr. Holden Chow. Thank you, Chairman. I would like to follow up on other members' questions. That is about cross-examination and fairness. The Law Society has submitted a paper, and one of the views is for 55Q, there are several factors to be considered when the court directs acquittal. So you have to look at the nature of the hearsay evidence, etc. And here it states clearly that if the person is unable to attend the court, or if he is incapable, then such factors have to be taken into account. So based on such circumstances, the judge would consider if the accused should be convicted. So would this allay members' concern? I've been listening to Mr. Alan Hu. I think he has his reasons. Well, for our system, we do not want to rely on paper trial. There should be face-to-face examinations. That is very important for a trial. We do not want to rely on a piece of paper. If that person is not here, we do not just want to rely on a piece of paper. So I think he is reasonable in saying what he said. So would you make it clearer? That is, can the arrangement for a cross-examination be included here? I would like to thank Mr. Holden Chow. He asked a very crucial question as to whether there's cross-examination. That is really an important point to consider. Now, if you look at the Law Society's submission, and actually last time I also answered Mr. Dennis Kwok, the Bar Association also asked similar questions. But if you look at this more carefully, you will see that whether there's an opportunity to cross-examine and using this as an element for consideration, it is quite different from what the submissions say. That is, they talked about the admissibility. So at that stage, we do not think that we should set out the cross-examination arrangements here. Now, because this is a hearsay evidence, and for any hearsay evidence, there's no cross-examination. So when we talk about hearsay evidence, there's no cross-examination. So when you talk about admissibility, the court would know that that's a hearsay evidence without cross-examination.
Mr. Chow just now refers to 55Q, and it's very clear. Bracket 5, bracket E says that any prejudice to the accused which may any prejudice to the accused which may be accused by the omission of the hearsay evidence, including the inability to cross-examine the declarant. So in assessing facts and weight before deciding whether to admit the hearsay evidence, the court will have to consider an acquittal based on hearsay admitted in this regard will be unsafe. So it's rather, we have already struck a balance. Any other members? Mr. Porte? Perhaps I will follow on what I said last. I asked the administration and people attending this meeting. That was the LRC report in 2009. Well, as you've heard, that they have adopted the New Zealand model. Have you studied its impact on prosecution? In terms of implementation, some inbuilt safeguards. Have you studied the implications in the New Zealand model? The LRC looked into this topic. They looked into situations when it would help the defendant. They have cited some cases, some UK cases. It says that before the reform, there were circumstances when the defendant asked the court to accept hearsay evidence. The court could not do so. When deciding which model to use, of course, the LRC has considered the pros and cons of different models. we have heard from different stakeholders, and when we were collating their comments, we have also referred to cases of the different jurisdictions. We have not, however, compiled statistics on the quantified result. In some cases, including UK ones, say for example, whether it is reasonably practicable, that is, whether it is that is not subjective. There are some UK cases that courts can rely on. The way the provisions are drafted is similar to those in the UK system. We think that this proposal is suitable for Hong Kong. Perhaps I will hear from Mr. Hu in relation to what Mr. Wong said. The point raised by Mr. Zhe was whether it is criminal proceedings, whether it is defense or prosecution. Well, the prosecution's doing all the work. The defense does not. You have first move, and then you use hearsay evidence to get me convicted. This will end up in a paper trial. Are you serious? I've been practicing for 40 years. Well, there has been occasions, well, I can't think of an example when I think that not being able to tell hearsay evidence hinders justice. Regarding vulnerable witnesses or mentally incapacitated persons, well, you can just confine the applicability to these two groups of people. On one hand, you said that it is New Zealand model, and then in the same breath you talk about UK cases. Why didn't you use New Zealand cases? What happened to Pays? If in 55 it says that if the inculpatory statement is the only evidence, then it cannot be admitted because there is no cross-examination. It's not just about a coerced confession. You really have to think twice. Well, we can just use Pays. Mr. Choi would like to add. Please be brief. Well, I agree partially with Mr. Hu. In the LRC report on arrest 1992, it has touched on this. In the police ordinance, it's not like UK ordinance. If you want to change the hearsay rule, it may not apply to the defendant, but it may. But what about protection to people involved? Mr. Hu talked about whether something is to be added. Well, there is something I don't agree with him. Dr. Zheng said that, well, mentioned about mentally incapacitated person. 55-0 covers different situations, say for example when the witness has passed away. when we talk about hearsay evidence, well, it should be general, not just applicable to mentally incapacitated person. Well, you need to add something to enhance protection. But I think that legislating for hearsay evidence is the right direction. Perhaps we'll hear from Dr. Zhou first. Oh, Mr. Jie, please continue. We have to refer to the LRC report 2009. It's been quite some time, I may not remember correctly. The UK model, New Zealand model, what's the difference? Can you give me the merits and shortcomings of each model? Can you explain why you have decided to adopt the New Zealand model? Mr. Hu said that if you have adopted the New Zealand model, then you need to use New Zealand cases because it will be more fitting. Can you give us some New Zealand cases so that we will better understand how the court deal with these situations and what is the progress and what difficulties are encountered, so that we know what to look for. You want it in paper? Maybe we will get a brief explanation before we get the written reply. Solicitor General, can you give us a brief written reply on the two different models? I thank Mr. Jie for the suggestion. We'll be happy to juxtapose the two models. And if there are cases, and if we find more information, we'll be happy to provide them. Let me give a brief reply about the biggest difference between the two models. Under the New Zealand model, we have taken reference, we've added two tests. The second one is 55P, condition of threshold reliability. This is an additional requirement on admissibility of hearsay evidence, which is an extra on top of the UK model. For the UK model, you can refer to 55O, the first requirement, which is condition of necessity. So there is additional safeguard. And it shows that we're not trying to make it easier for the defense. Cross-examination is the core of a criminal trial. But for some people, it can't be done. Say, for example, people who have died or people who can't attend court to give evidence. Say, for example, the female inmate in breach of rehabilitation, that home. They are incapacitated to give evidence under cross-examination. They are the aggrieved party, and they have made statements and given evidence in a different way. It's just that it's not a testimony in court. If, as a result, their evidence is not accepted, I'm afraid that is too calcified and it's not fair. If by changing the hearsay rule you can introduce comprehensive evidence, then I think we should do it. I don't really understand the concerns of Mr. Hu. As Mr. Wong said, we have 55 P and Q. There are also safeguards. In 55O, condition of necessity, A, B, C, D are all reasonable. It's just E that I have a problem with. Mr. Hu said perhaps this is superfluous. I'd like the Solicitor General to explain. Refuse to give evidence where the declarant would be entitled to refuse on the ground of self-incrimination. Is it too lax? I find the others acceptable and reasonable. Who is to take the question? Dr. Zheng refers to the concerns of Mr. Hu. Dr. Zheng may find it difficult to understand because confessions by the defendant was mentioned. That is something completely different.
That is about the defendants confessing outside of court, and can that be used to convict the defendants? So this would be dealt with separately. And in the bill, Schedule 2, you would see confession, and we follow the common law practice. That is for the defendant. Well, that is about the defendant himself. And now we are talking about the witnesses other than the defendant. I'm sorry, Chairman. For the LLC report, the relevance issue is mentioned. That is for a defendant, if he has to stand trial, and one of the scenarios set out here is like this. That is why the hearsay evidence should be admitted. That is, if the accused has some accomplices or there are other co-accused, or actually these people are not accused in the same trial, and their evidence may affect the fairness of the trial. Under such circumstances, we think the new provision should be used. This is what the LLC cited as an example. Chairman, I don't know if there's still time left, but it seems that there are not many members here. I still have some questions. Mr. Holden-Chow, do you have questions? Just now, I've been listening very carefully to the Solicitor General. So for E, it's not about the accused. It's about people who may be involved in the case, and they are worried that if I come to testify, then I may incriminate myself. So people may have such concerns. So under such circumstances, he would not testify. And if this bill is passed, then according to this bill, his hearsay evidence may be admissible. This is my understanding. Am I correct? Yes, this is about whether the court should admit such evidences. If the bill is passed, then the court can admit such evidences, and the evidence can become part of the evidence. But as to whether he's satisfied with the evidence is about a balance of probability. Well, maybe this is Mr. Allen who's concerned. Well, both scenarios may happen. Supposedly, the prosecution can ask certain people to testify, but they do not need to appear in person. Then the evidence they adduce can be admitted under 55(0)(e). That is, he doesn't want to incriminate himself, but his evidence is still admissible. So the burden of that person giving evidence is much lighter. And it would be easier for the prosecution if a third party is willing to adduce evidence to prove the accused is guilty or not guilty. Then the threshold would be lowered because of this amendment. So can the DOJ explain more? For the reliability of evidence and for 55P and Q, that is about the threshold reliability, and 55Q, court must direct acquittal if it is unsafe to convict. Well, can this safeguards be enough? I would like to thank Dr. Chung for his questions. I would like to explain more. Now, when it comes to the fairness of criminal proceedings, we don't just look at the provisions in the evidence ordinance. Now we are introducing this reform, and we have clause 55Q. This is the ultimate safeguard. That is, if the court think that the hearsay evidence is admissible, even though those two conditions under 55(0) and P are met. If the judge thinks that it's unsafe to convict, then the accused must be acquitted. But if we look at it more macroscopically, for criminal proceedings, there are other safeguards. Mr. Porche also mentioned this. Now, we do not want to convict people if there's still doubt. So when it comes to the burden of proof, it's different. The prosecution would have to adduce evidence, and it has to be beyond reasonable doubt. And for the accused, they do not have to reach such a high level. So for the burden of proof, there are also two levels. For the first level, that is about the convictions. Under 55O and 55P, for the prosecution and defense, if they both use hearsay evidence as to whether the evidence would be used for making the judgment, and if it's conducive to the prosecution and not the accused, then the prosecution will have to satisfy the higher level, that is beyond reasonable doubt. This is the first level. As for the other level, it has to be proved that the evidence has to be admissible. There is also a threshold. That is 55O. For 55O, to pass the test of the condition of necessity, then under 4A, B, you can see the standard of proof. The standard of proof required to prove that the condition of necessity is satisfied is A, if the applicant is the prosecution beyond reasonable doubt. So if the prosecution wants to invoke this provision, he has two thresholds. First, for the hearsay evidence, he has to prove that it should be admitted by the government. And when it comes to conviction, that is when there is a jury and when it's a public indictment, then the jury would have to accept that there is no reasonable doubt before a conviction can be made. So when it comes to fairness, for the prosecution and the defendant, the prosecution would have to reach a higher level before an accused is convicted. And what we are looking at now is for certain evidences, because they are hearsay evidences, so no matter how reliable the evidence may be, well, because it's hearsay evidence and under the common law he cannot find exemptions, then the courts cannot accept them. And this is not ideal, because logically there may be problems. And this may be detrimental to both the prosecution and the defendant. So after this study, the LLC has come up with the relevant recommendations, and the government thinks that the LLC's recommendations should be implemented. So that's why we have submitted this bill. Mr. Paul Chair, I would like to know more about the New Zealand model. Well, do they have this Hong Kong practice? That is, there is a schedule, and for those that's already under the common law, that is confessions, joint enterprise, or conspiracy, expert opinion, etc. Do they also handle this in a schedule? I remember the Solicitor General said last time, he told us why they are not redoing it with statutory law. And Dr. Chung and Mr. Alan Hu have mentioned vulnerable witnesses. And that can be dealt with by statutory laws, or now we are doing it through a schedule. Legislation is a method, And if the common law is not clear, we want to make it clearer. Now, this time around, you have chosen the New Zealand model. And for most of the scenarios, you are using statutory law to do it. But when it comes to confessions, this is a very big area. But now you just put it in a schedule. You are saying that you are sticking to the principle. So I don't think this is ideal. So can you tell me more about the New Zealand model? Thank you, Mr. Chair. Well, for the New Zealand model, they are not like us. They are not using a schedule to retain certain elements. Well, these are some common law principles that we want to retain in Hong Kong. Well, for this, we have taken reference from the British practice. The advantage of doing this is that well, we have studied these 8 areas, and these common law principles should still be applicable. Now, the court can look at the jurisprudence of this. For those that are not retained, that would be like the New Zealand model. Well, the LLC suggests that these 8 areas be kept.
O
55O and P, the 2 tests, will be used to deal with hearsay evidence admissibility. The LRC has considered it over a very long time. They have also referred to cases of different jurisdictions. In the end, they find this approach to be appropriate. The DOJ has adopted this proposal to implement the recommendation. Of course, it is good to learn from experience. However, they don't use the common law principle. I believe that Mr. Hu is very familiar with what happened. Do we really have to legislate under the statute law framework? Mr. Hu suggested that perhaps targeted groups will be included, just like the groups mentioned by Dr. Zhang. Expand the scope. You can do the minimum instead of introducing an overhaul. It seems that you have given the wrong impression by introducing huge changes. It may be a paradigm shift. It may not be true. We will have to look into it in detail. But it's quite a big gesture. Why? We have taken reference from the practice of other common law jurisdictions. First is about the concept of hearsay evidence being inadmissible. That concept applied in the past in both criminal and civil proceedings. In the civil law reform, this rule has been abolished. We have kept it in criminal proceedings. In a lot of common law jurisdictions, after they have conducted a study, they thought that it had to be done by reform through statute law. I recall that back in the 1960s, at that time there was no Supreme Court. There was the House of Lords, and there was a case which stated very clearly that under common law, the court cannot create exceptions. So if exceptions are to be created, it has to be done through legislation, by statute law. In different jurisdictions, it's usually done by applying thresholds like 55p and O. We have considered it. We think that the 8 exceptions under existing common law should be preserved, and we have done so. The LRC has done studies into different jurisdictions. They have listened to views expressed. The DOJ has conducted consultations. We decided to amend one area. It is 55Q, the safeguard. If the court thinks it is unsafe to convict, then it must direct an acquittal. We think that this safeguard has struck the best balance. As a result, we have decided to do it this way. Mr. Holden Chow, to be followed by Dr. Fernando Zhang. Thank you. Well, you might have thought about this. It's just an idea of mine. We have 55QE. You have included the views of the Law Society, inability to cross-examine the declarant. What about serious cases or cases involving a lot of people? Under the bill, people who were involved in the case in the past, they don't have to testify in court, and hearsay evidence would not be admitted. But what about 5-6 more people in the case? They may not be defendants. They do not go to court to testify, but they have hearsay evidence to give. Well, will there be more for the court or the jury to consider? Say, for example, well, you have to consider the fact that there are people who have not come to testify. You have to consider the importance, whether there is any unfairness. But there are more things for the court to consider. Is there a chance that, well, the likelihood of a conviction is higher because there is more for the court to consider now? As a result, there is a higher chance of conviction. Would that be likely? I thank Mr. Chow for his question. It's not the case that we have an assumption that the defendant will be acquitted or otherwise more easily. What we bear in mind is that evidence that should be admitted will be admitted by giving the court power. Because this has not been rationalized, currently the court cannot consider evidence that they could have considered. And if there is more evidence to be admitted, we need safeguards. That's why We have set the threshold at 55 O and P, and even after pass these tests, it means that it is admitted only. But whether they are believed, you will have to refer to 55Q. Regarding cases that would not have been prosecuted, or whether there would be cases when the defendant would have been acquitted. Yes, I can give you some examples. It's a case in the 1990s. It involves children, not necessarily sexual offenses. In the past, for minors to give evidence under the common law system, certain conditions will have to be met. Say, for example, can the person testify under oath? If the person cannot testify under oath, the person may still testify. But since it's not done under oath, there are other problems. Say, for example, whether there is collaborative evidence. After the reform, we have abolished this requirement. We have at the same time put in safeguards. Say, for example, the court will have to give reminders to the jury. And as to whether there are cases without collaborative evidence, the minor could not give evidence under oath. As a result, prosecutions were not initiated. Yes, there are these cases. We would like to initiate prosecutions as much as possible because we think that evidence that should have been admitted should be admitted by the court and should not be excluded because of some calcified and illogical rules. In the end, we aim to ensure fairness of trials, and we do not want to contravene the general principle of convicting an innocent party. What if this has been introduced a lot earlier? The case of breach of rehabilitation would have been done differently. There would be a different outcome. I would like to ask something about what Mr. Hu said. That is, not attend court for cross-examination for fear of self-incrimination. The Solicitor General said that 5004 in relation to condition of necessity. Well, the prosecution will have to prove the case beyond reasonable doubt, which is a very high standard. When I refer to A to E under 55O, say the declarant for fear of self-incrimination refuses to give evidence. I think it's easy to prove. The person says, I don't want to go. So you can say, well, I'm using 55O bracket E. So is the threshold indeed that high? I have doubts. Can I hear further from the Solicitor General? the Solicitor General is talking about the second tier standard. That is on top of 55p, the threshold of admissibility of hearsay evidence. There is also the high standard of proving the case beyond reasonable doubt. I was saying that it's easy to meet condition E. Can you explain? Perhaps I will answer Dr. Zheng about threshold. Sorry. Well, this is time for members to ask questions of the administration. Of course, I can ask Mr. Hu to explain. I would not stop him from speaking because of some rules. I fully understand you. I think we need to reform. I agree with A. Yes, the witness has passed away. B. Definitely. The declarant is unfit to be a witness because of their age or physical or mental condition. There is also D. You can't find the declarant. However, E. There is no need. There's never been a need. You can't say that I don't want to be cross-examined because I don't want to incriminate myself. Well, for C, evidence can be taken outside Hong Kong. So I support A, B, and D. But don't piggyback C and E onto it.
呢個紐
Just now, Mr. Chair mentioned the New Zealand model. Now, for New Zealand, they have enacted two pieces of legislation. One is about the hearsay evidence. The other is about PACE. That is the Police and Criminal Evidence Act. These are set out very clearly in the law. So what they are doing now is not lowering the threshold, because in the past it's not admissible. It's not about the height of the threshold. At least in New Zealand, they have two pieces of legislation. Now, why do they have the common law, and on the other hand, they have to legislate on this? In New Zealand, for all the criminal proceedings, there are juries. But in Hong Kong, for 90% of the trials, we do not have jurors. So for a magistrate or a district court judge, when they look at the evidence, they think that is reliable and is admissible. But would the judge think that is unsafe, so he doesn't convict the accused? Because he's already admitted the evidence. But after the admitting evidence, would he think it's unsafe to convict the accused? Then what's the use of admitting the evidence? So it's not only about cross-examination, and also this hearsay evidence is not taken under oath. Solicitor General, do you want to respond to what Mr. Allen Hu said? Well, for Mr. Zhang's question, it's about 5504A and B. It's about the burden of proof, or the standard of proof. And this is about 5501E. That is the declarant or the witness refuses to come to the court. Is it because he's afraid that he would incriminate himself? So we have to consider actual cases. Now, of course, under some circumstances, the witness would say that, "Oh, I'm afraid of self-incrimination, so that's why I will not testify." But in real life, the witness may not tell you this story. They may refuse to answer, or they would give you another story. So if we cannot find the witness, and even if we find him, he refuses to give evidence, then what's the reason? We have to look at the actual case. Now, if this person, you really find him, then you can give him a summons and make him appear in court. And if you ask questions which may incriminate him, then sometimes the judge may remind him, or he might have obtained legal advices already, and he will say that I refuse to answer this question. So for the relevant questions, you cannot force him to answer. This is the present situation. Earlier on, I mentioned the LLC example. It's actually a UK example. Now, if you cannot find the declarant, but there are other people who've heard what he said, and for this declarant, which you cannot find, under other circumstances, it can be proven that he fears that he would self-incriminate. So that's why he doesn't want to be found, or he refuses to say anything more. He said it earlier once. So this is about the burden of proof, or the standard of proof. Well, earlier on, he said this, but now he's afraid that he would incriminate himself, so he doesn't want to testify. So it depends on whether you are the prosecution or you the defendant that wants to use the hearsay evidence. If it's the prosecution, then according to 5504A, you have to the requirement is beyond reasonable doubt. So in real life, there is indeed a difference. Members, any other questions? Dr. Fernando. Well, earlier on, I and some friends talked about hearsay evidence. And we also talked about cross-examination arrangements. We have also exchanged views with the DOJ. At that time, we considered ground rules hearing. I don't know what it is in Chinese. So it's like a pre-trial. So it's a kind of arrangement in which the judge can set out rules concerning the method of cross-examination or the contents of cross-examination. And in some other places, they may use intermediaries or testimonial intermediaries to replace the lawyer of the other party to carry out cross-examination. So for vulnerable witnesses, this would cause less damage. Of course, the judge would have to make the decision and set out rules for this. So for this bill, there is no arrangement like this. So I would like to ask the DOJ, have you conducted studies on this? In the future, would it be possible to introduce new measures like this? Thank you, Chairman. Well, some NGOs have talked to our prosecution division. But for this bill, it's not about this issue. Just now we heard Mr. Allen Hu's suggestions, but what is most urgent now is this reform. We hope that the reform can be implemented as soon as possible. We understand that the criminal prosecution department is talking to the NGOs. We understand that there are some codes of practices already, and that's promulgated by the judiciary. And I believe that the operation has been smooth. Yes, thank you for your extra information. If members have no other questions, I think we can end the public hearing today. And now it's already 6:25, so I don't think we would start the clause-by-clause examination this time around. So let's wait for the next meeting. AOB, next meeting date, 10th of December, 4:30 in the afternoon. So we'll adjourn the meeting now. Thank you. Thank you for attending the meeting.